Good evening, everyone. I hope I'm audible to all. First of all, I will like to apologize to all because I was traveling. I had gone out for my arbitration matter. I'll start the session just in 5 minutes. Just give me 5 minutes. Dhruvji, am I audible? I can't hear.
Yes, madam, you are audible.
Okay, fine. Just
Okay,
5 minutes and I will
okay,
connect.
okay.
का फोन करताय एकदा कट केल्यावर कळत नाही का की ऑफिशियल काम ते म्हणून.
Uh, okay, guys. So we have Dr. Ritu joining the meeting. So I guess we will start with the meeting. But before that, I will just give a brief introduction of Dr. and Advocate Ritu Bharadwaj, ma'am, who is going to be taking a session today on the topic "Rule cannot be changed after the game is over." So, I will just give a brief introduction about Advocate Ritu Bharadwaj first. She is a seasoned advocate at the Supreme Court of India and senior associate at AAR Legal Association with over 19 years of distinguished practice. She serves as a Central Government Counsel on the Supreme Court panel and has represented various corporations, PSUs, state governments, and universities. She is a certified mediator at the Supreme Court of India and specializes in conflict resolution and ADR. Formerly the Joint Treasurer of the Supreme Court Bar Association and Joint Secretary of the Legal Assistance Forum, Advocate Bharadwaj has handled landmark cases involving constitutional interpretation, education law, criminal law, taxation, and land acquisition. Her vast experience and leadership make her a respected voice in India's legal and mediation community. So that was just a brief introduction of Advocate Ritu Bharadwaj. And now we will be starting with the meeting. Without any further ado, Dr. Ritu Bharadwaj, you can start with the meeting.
Thank you so much, Dhruvji, for your kind introduction. And I'm starting. I was traveling actually. That is why I've just entered. Give me 2 more minutes. I will start. We will not further delay the things. Just 2 minutes. Hi, good evening. Am I audible?
Yes, ma'am.
Okay. Today, what we are going to discuss is rules what we cannot change after the game is over. Here, we are going to discuss something about the constitutional perspective. And like Dhruv has already given my introduction, I will also like to tell you this matter in Constitution bench. I was the leading counsel in this matter, and for many days we had an argument in the court by a 5 judges bench, and we had discussed about fundamental and legal constitutional principles, which has been repeatedly by Supreme Court of India in many matters. You must have gone through many of the matters regarding this rule. This doctrine is not just you cannot just express it in words. It has to explain how fairly the system of law is working for our constitution. What is the meaning of this principle? First, we'll discuss this. May I know, Dhruv, like what students are like, which term students are sitting over here?
Ma'am, we have students right from first year to last year. We also have practicing advocates as well.
Okay,
So we have a mixed batch.
okay, fine, fine. Welcome to all to this session, and I hope a few things we I am able to explain to you regarding the expression what we have used in this matter. I was handling the matter Tej Prakash Pathak versus State of Rajasthan, which was the leading matter in the court in the constitution bench. The matter is regarding the rules. Again, I will tell you what it is. What is the principle? The principle says that once the process has begun under a particular set of rules, what you can say, the authorities cannot alter the rules, which means if the rules are given in the advertisement, if it has got conditions, what are the conditions to get through in the process of getting through any of the employment, then those conditions should be followed throughout. They cannot be altered in midway or even after the completion of a particular outcome. If it has been taken, even the participants are participating in the interview session or in the written session or any of the session, if they are taking part, it cannot change it. What does the rule says? The rule says that it is going to safeguard. It safeguard what does it safeguard? It safeguard the rights of the person. What? The administrative and academic and recruitment process, which is going to start by the rules are given in the advertisement. The same standards have to be applied to all the participants throughout, and it has to be, what does that mean again? The authorities, they have to keep the transparency. The decisions which are taken, they have to be predictable, and constitutional rules have to be followed by all the authorities, whosoever is taking the competition or the interview board, whatever the rules are given. Suppose in the advertisement it is written that we need the graduate candidates in for this examination. Now, after the process has been started, the authorities cannot change their views, and they cannot say anytime they cannot say that now we want postgraduate candidates. This is what the rule has been changed, because at the time of the advertisement it was written the person whosoever is going to apply in this procedure of selection has to be graduate, which means the principle derives its strength for Article 14. Now, everybody must be knowing the Constitution. The Article 14, what it says? It says that there has to be equality before law and protection against the arbitrariness. I hope I am clear. Am I clear to all of you?
Yes, ma'am.
Okay. So what I am explaining here is when we talk about the rules, regulations, which has to be fundamental rights, it has to be, it has to be accompanied by the constitutional rights, which says Article 14, which is about equality, Article 16, which says equal opportunity in matters of public employment. Then the doctrine of legitimate expectation and promissory estoppel, which means when an authority invites any participation of any of the examination or any of the interview, if the specific rules have been given in the advertisement, every participant acquires a legitimate expectation and those rules will remain unchanged till the process concludes. What does that mean? The process has to be started and it has to be ended with the same rules and regulation. Although many judgments had come, which we had discussed in this matter, like K. Manjushri versus State of Andhra Pradesh, you can write it down. You must be aware of regarding all these matters which has been already taken place in Supreme Court and has been decided in different years. But one of the important matter was K. Manjushri versus State of Andhra Pradesh, 2008, Volume 3, SCC, page number 512. Am I clear? Have you noted down? K. Manjushri versus State of Andhra Pradesh, 2008, Volume 3, SCC 512, page number. So what that judgment had said, the Supreme Court struck down the selection of candidates when the interview marks were increased after the written examination was over. They said, court observed what? That the rules of the game cannot be changed after the game is played. So first time it was mentioned in that matter. It held that the criteria for the process of starting the selection procedure, it cannot violate Article 14, which is the principle of fairness. Everybody has to be fair in the selection procedure for every employment, and that considers the Article 14, which says equality before law and protection against arbitrariness. So, Maharashtra State Road Transport Corporation versus Rajendra Bhimrao, that had come in 2001, and it was in volume 10, SCC 51. What that the recruitment rules were amended after candidates had applied in that matter. And the court held that the selection must be governed by the rules existing at the time of advertisement or subsequent changes after the it cannot affect the process which already underway. So that was already taken place in Maharashtra State Roadways also, and K. Manjushri had struck down the selection of procedure. That was the difference between both the things. That the court held that the selection must be governed. Governed by what? Rules. Rules are what? Which are explained at the time of advertisement, and subsequent changes cannot affect the process already underway, which means in between when the procedure is going on, nothing can be changed, no rules can be changed, no rules can be amended, no rules can be added, and in the same procedure when it was said, the same kind of matter was again discussed by the Supreme Court in the matter of State of Bihar versus Mithilesh Kumar. Mithilesh Kumar was in 2010, volume 11, SCC 113. Here, the court had said that the retrospectively alterations in selection criteria undermine the rule of law, which means if even the alterations have been taken place earlier, when even the law had not come, that considers the criteria which undermine the rule of law. But in context of the pensionary benefits, court had already held, it had held what? That the rights cannot be taken away. So in all these matters, they were discussing about selection procedure which cannot be changed, but every time there was different decision or different stand was taken in different matters by the Supreme Court of India. And that was the reason when many bunch matters had come to the court saying that we are facing too many problems regarding this same rule, because one court says something else, the other court says something else, the rules are sometimes changed, the rules are sometimes amended, the rules are sometimes added, which means all the courts are not following the same procedure. That is why all the matters regarding the same point, the same rule which was saying that it cannot be changed after the game is over had to be decided by the bench of 5 judges who had to decide this matter, that why such amendments cannot be taken place. And finally, the Honorable Supreme Court of India had decided regarding this that yes, rules of the game cannot be changed once it started. Once it has started means if the procedure of selection once had started, and it has been, somebody has called even the for the selection procedure, the candidates have already started the selection procedure, then the legal principle says that the rules of game now it will not be changed, and whatever the game had started in the beginning, following the rules of the advertisement or the conditions kept in the advertisement, it will not change, particularly in the context of recruitment and selection process. So this principle, it ensured the transparency and also the equality in the system, which prevented that the arbitrary changes cannot take place, which is because it can harm the candidate who has already begun participating under the original rules. Now, what are the legal, we should say, the picture of this rule? What does it say? It says Supreme Court, what did they decide or held in this matter? They said once the selection process has commenced, the rule governing that process we will not alter until unless this is the because this is to maintain the integrity of the selection procedure, and that is why we will follow the same kind of procedures whatever has been decided by the board or by the appointing authority. So candidates must should have the right to consider for the appointment based on the rules in place of their application whatever it is written, and same kind of matter was again decided by state of UP versus Karunesh Kumar. Now, what are the exceptions and clarifications regarding this matter? What we had discussed about the same matter at the time of doing this matter, arguing this matter, that changes that do not adversely affect the candidates or that are made for the benefits of all candidates may not fall under this principle. For instance, suppose if there are changes in the relaxed criteria for the certain group without disadvantaging others, they may be permissible, which means if it does not harm the other candidates, then it can continue. In some cases, courts have also allowed many of the procedures to alter the fundamental criteria for the selection also, because they were not including the violation of principle, which means the article 14 was followed by everybody, then there was no harm to anyone. In that case, even if the administrative changes were done, then also it will be considered that rules can be changed. Why the rules cannot change? Only what at what stage it cannot be changed? It cannot be changed in what conditions? In conditions when Article 14 is not affected, which means the criteria altered with the application deadline. Suppose in courts have already ruled such changes are suppose impermissible, and even if they are emphasizing that candidates prepared their original criteria that was different, and now what has been started by the system that is different, then that candidate cannot go for the candidate will not be, it will be considered what the court wanted to say, that suppose if the conditions have suppose at the last moment it has been changed by the authorities who are taking the interviews, if they have been changed, then it has to be accordingly, it should show that the article 14 is not affected. If the selection procedure is deemed to have not been commenced, suppose if it has not been started, and even the system has not been started, and All candidates are still in the procedure that they are waiting that what are the conditions it has to be followed, then even the changes may be allowed. That was said by the court, that administrative changes according to the system, if it is required, those will only be allowed. Otherwise, principles, that are the rules which cannot be changed once it is started in the critical safeguard, the recruitment and selection procedure, it will not be done in the country, and which ensures the fairness and protection of the rights of the candidates who are appearing for examination. Now, what was the catch of this? One of the court, when Justice Mishra had, he is the author of this judgment, and when he had written this judgment, he had given some criteria that the recruitment rules and criteria are communicated, should be communicated clearly and made clear to all candidates very clearly in the selection procedure, so that there has to be no confusion amongst the candidates. Another thing what was said by the honorable court was that if the client or the select candidate who is appearing for the selection procedure, if he is affected by any of the changes, and or if he is emphasizing the established rules, and if he says that the arbitrary alterations have been done by the system, then the then they can go to the court, or then they go to the system and they can mention about it, because it has been decided by the 5 judges bench. Monitoring by amendments to the recruitment rules, it is closely what it has been decided, that compliance with the principle is necessary in any of the selection procedure by the court or by the authorities, even in any of the system. If it has gone against the rules or regulations or whatever the condition has been decided at the time of recommendations or the selection procedure conditions in the advertisements, then the person has got all the right to go to the court. Now, in this system, in this matter, when it was started, what was actually why we had gone to the court? What had happened in this particular matter, which I will like to tell you. There were a bunch of employees, in many of the system, like in judiciary, many of the you will go through many judgments where even judiciary officers, they had gone to the court regarding the same, that the rules have been changed. Their court was very clear that if the system allows the administrative changes even at the last moment, they will be done, and the candidates cannot raise their voice against it, because the criteria of honorable high court regarding the selection of the judges, it changes according to the situations and the system. Whatever is going, it will be decided by the bench or by the chief court at the time of, even if that at the time of interview it can be told. So that was the system which was decided by the court in any time. And in this matter also, when there were many matters which were included in this in this matter, more than 70 matters were they were attached with this matter, and when the arguments were going on, all the matters were sent to the different courts, and honorable court has allowed that these matters will be discussed and heard by the different benches, and they will uh, take their own call, and they will decide their matter according to the need of the particular matter, because all matters might be they are not in the same category. Why they have said this? Because in doctrine of changing of rules, they have a strict application for both the eligibility and selection criteria. Selection criteria is what? Are you getting? Are you getting, all of you? What is the selection criteria? Can anyone answer? I can see many of them here. Any of you? Have you got through that? What is the selection procedure at the time of which stage the rules have to be made? Please explain. Any of you? Am I not audible? I can
Ma'am,
see.
you're audible. You're
Yeah.
audible.
Please tell me what actually the court wanted to say, that why at what stage the rules cannot be changed, when the rules of appointment cannot be amended. Tell me, anybody? Can appointments be denied due to change in eligibility criteria? Anybody can answer this question? No, the appointments cannot be denied due to a change in eligibility criteria at the last moment, because Honorable Court had decided that the rules cannot be changed in mid of the way. Please tell me, what do you want to say? I could hear somebody's voice. Somebody wanted to ask something.
If anyone has anything to say, they can turn on their mic and
You
directly
please
say it.
turn on your mic and ask me what do you want to say, because here I am saying that the submissions were what we submitted to the court was it was based about the infringement of their equality rights, the right to clarify and fair notice that change in rule is not good for any of the candidate whosoever is appearing for the selection, and discretion is bad in rule of law. You cannot discriminate anybody. That's the base of our constitution. And that is why this was the constitution bench. It was the matter was taken by 5 judges bench. An honorable Supreme Court had decided this matter. The respondents, you know why they were after this, that the change is permissible and flexibility and discretion should be there in the recruitment. Why they were saying? They were saying because not that they wanted to violate any constitutional rights, but they were saying that if a change is in the larger interest of the efficiency of the service, then they should be done. And that lordship had allowed that yes, if it is like this, that it is in the if changes are in the larger interest, then the changes are fine and it can be taken place, informing them that the this criteria has been changed at the time of the interview or at any of the stage, because court said that a doctrine of changing of the rules are not strictly applicable in every selection process. Sometimes the rules can be on the basis of the administrative changes, or sometimes there is might be it affects sometimes equality in matters, but in the larger interest, if it is related to a public employment and if it is in the larger interest, then the changes can take place. The judgment also relied on the legitimate expectation that participating candidate in the recruitment process, he has the expectation that the process of selection should be, although fair, and it should not be arbitrary, but the expectation of the candidate has to be created due to his own knowledge, his own criteria of coming to for the selection of in the system. And that is why the person, every select candidate, whosoever is going through the process, that person always expect that the last moment rules change is not good, and it prevent the that is why all candidates have gone to the court to prevent for the recruiting process authority from moving away from the standard policy. Now, have you got any idea? Now, can you tell me the same question? Can appointments be denied due to a change in eligibility criteria? If you are not going to answer, I will
No,
understand that you are not getting me. That what I am saying. Please tell me.
no, appointment cannot be denied. Right.
Appointment cannot be denied in certain conditions
Right.
when the changes have been done only in the larger interest. If it has been done, then of course appointments can be
Can
denied.
be considered.
Otherwise, appointments cannot be denied after the selection procedure is completed or it is over. It cannot be changed at the last moment.
Right.
Okay.
Yeah.
One more thing, the employer, if the selection process is like, suppose if there is a compelling public interest and changes must adhere to constitutional mandates. Okay. So although they are supposed to be transparent, they have to be non-discriminatory, they cannot be arbitrary, they cannot be, related to your their own personal interest should not be there. And person with an experience of more than, suppose, any of the year experience, if it is given, it cannot be, year of experience cannot be increased at the last moment at the time of interview. No, we wanted 10 years experience. No, if it is written 7-year experience, then the same thing will be considered by the court. And that is why candidates who had been, suppose they have been shortlisted and they has their suppose the right they have come to the last stage, then they cannot be avoided for the appointment. They have to be considered for the appointment. And if there are vacancies available, then the system should always consider them. And if suppose if the vacancies are filled and the new vacancies have not come, there are so many matters in which council were saying that the vacancies are not available. And suppose if that time, because when we had applied, we were kept on hold and somebody else had joined the employment, then what is the procedure? How can it be accommodated? Then also court had given one that was a direction only to the different departments that they should be considered whenever the vacancies are available. And it does not mean the burden is on the state to justify that why they have not been appointed as a candidate from the select list or short list, but it is only the direction that they should be considered whenever there is some vacancy available. So the select list cannot be altered, although if the procedure has been begun, but they will be considered if the vacancies are available. So, upholding the K. Manjushri court had observed that the president emphasized that any post recruitment modifications, they will violate the candidate's right to equal opportunity, and the extent rules or advertisement of the post may also permit to alter in the eligibility of criteria, but such alteration should not meet what the, tell me, somebody should answer. Such alteration should not violate what? Please answer, anybody. I will consider everybody is sleeping. Please tell me.
Ma'am, please repeat your question.
I am saying, suppose the rules of advertisement or the post, they have been permitted an alteration in the eligibility. Okay. Suppose condition was something else earlier, but later on they got the permission, authority got the permission to alter the eligibility criteria. Then such alteration should not violate what? I had already explained that. It should not violate the requirements of Article 14.
Okay.
It should satisfy the test of non-arbitrariness. Nobody should violate the Article 14 at any cost, at any reason, at any time, at any situation. So, the reference order of the Honorable 5 Judges bench suggested what? That the K. Manjushri was in conflict with Subhash Chandra Marwa case. You should go through both these judgments, K. Manjushri also and Subhash Chandra Marwa also. So the Honorable Court said that this Pathak matter, this was observed what that the Manjushri dealt with the right to be included in the select list, that is eligibility criteria. And Subhash Chandra Marwa, what dealt with? It dealt with the right to be appointed after being included in the select list. So they said that K. Manjushri was different and it was in conflict with Subhash Chandra Marwa, and that is why the present judgment clarified the doctrine rather than deviating from the existing jurisprudence, but it said that it is the different one and the rules can be amended only if it is in the larger interest. Otherwise, there is no requirement to violate Article 14. Am I clear? Am I clear to everybody?
Yes, ma'am.
Huh?
Yeah.
You should
Yes, ma'am.
also, you should also go through one of the matter Union of India versus T. Sundaraman. That is of 1997, if I'm not wrong. 1997. Please write it down. You have to go through these judgments to understand and to differentiate again, because to explain all these judgments, I need another 2 classes. In short, I am here to tell you why Tej Prakash Pathak was there, and Tej Prakash Pathak was only to explain regarding the fundamental right. Okay, so we have to be very clear about the judgment, that why judgment has explained about recruitment process which cannot be different in different times. Okay, am I clear to all? If yes, I can see Sumit, Arpita.
Yeah.
Yeah. So yes, which judgment you want to be repeated? Somebody is writing. Vaibhavi, okay, you are getting. I am happy. Dhruvji, I think we have to do one more session to explain the difference between regarding all 3-4 judgments which are discussed by the bench. Because right now I am talking only about Pathak versus State of Rajasthan. Right? So when it was considered at the time, Lordship had only explained regarding the rules which cannot be amended by the Supreme Court of India. It had said only in few exceptional cases it can be amended. Otherwise, it cannot violate the Article 14. And what are the changes? If everyone is interested, we can have one more lecture where we can differentiate between all the judgments, that what 1, 2, 3, 4 there were, although in one sentence I've already explained to you today what are the difference between all, but still you should go through K. Manjushri, Subhash Marwa. You please read all of them. I think things will be clear. And if it is not, then we can have one more session because it is important one. And in all examinations, if service matters are considered, then this is one of the most important matter which has to be discussed. Okay. And now I have to move. I have got another session also. Thank you so much and wish you all the best. And if regarding Dhruvji, thank you so much for giving this opportunity. And I have explained the judgment of a constitution bench, which I had myself, I was the leading counsel of the matter. And we will discuss one other matter again next time. And if this matter is not clear, some I should be conveyed. I can send you the notes also regarding 4 matters which were basically considered by the Constitution bench. Okay. Thank you so much once again. Wish you all the best for your examination, for your any of the selection procedure. If you are going
हेलो
through the review, yes, tell me.
मैम मुझे पूछना था कि ये जो वर्षीय पाठक का आप जो बताते हैं वो कहाँ कौन से इससे साइट से लिया जाता है
Site se.
एग्जाम्पल
I will share with the Dhruv and it will be shared with you. Okay.
जी मैम
Although you
थैंक यू
can go
मैम
to the Supreme Court of India site and you can get it there, but still I will share the judgment with Dhruvji and he will share this judgment with all of you. Okay. Thank you so much once again. Have a great time.
Thank you, ma'am, for joining the meeting. We are
Thank you
really
very
grateful
much
to
for
have
this
you.
opportunity.
Thank you,
Thank you
ma'am.
so much. Thank you. Good
Thank you all
night.
for joining the meeting.
Okay, bye.
Thank you, ma'am.
थैंक यू मैम
Thank you.
Thank you, ma'am.